As you are no doubt aware, Stearns' defence team has been filing multiple motions. I think it's well over 70 motions in advance of his trial, most of which are in fact somewhat preposterous. As you may have seen in the video that I put out, I think yesterday or the day before, where Stearns' team argued that his parents should be allowed to give victim impact statements prior to sentencing to let the jury know how much it's going to impact on them should their son get the DP. And of course, Will J stepped in and did the response to this, or to that one, and basically pointed out the ridiculousness of their argument. Seems that with this same motion that I'm going to talk about today, once again, you have Will J stepping up to the mark. So, the Big Daddy himself, I'm not sure if that's probably the right term, but we know that this is a seasoned prosecutor. Will J is well known for the Sarah Boone case, just for starters. You know that when he steps up to the mark, you're going to get a good response. And that's what we get with this one. So the motion that was put forward by Stearns' defence team, as far as I can recall, and we'll go back through this as we go through the document anyway, is that he wanted to present as a mitigating circumstance mental health issues. And I think in particular, this whole brain damage claim, with him saying that he has brain damage from being run over when he was 8 years old, and that is the reason for him doing what he did. Of course, while he wants to be able to put forward this claim, he wants to be able to put it forward without having to provide evidence of this claim, and without this is the great bit, this is the bit that this document basically discusses, without the prosecution being allowed to have their own tests done by an expert, their own assessment done by an expert, meaning that they really wouldn't have much in terms of rebuttal. And of course, as ridiculous as that sounds, that's what Stearns wanted. So Will J has come out swinging and basically done a decent response to this motion that was filed by Stearns' team, which well and truly slams them back down, in my opinion. So with that said, let's read through this response from Will J so you can see precisely what the argument is here. Now, before I jump in, I should probably mention I have just made myself a note, big sticky note that's now staring me in the face, reminding me to put this motion and the motion that I covered the other day on Patreon for people. Also, I am attempting to get those emails up on Patreon, and something was going on with that and it wasn't uploading when I tried it yesterday, so I'll try that again this afternoon. So for those of you who are not familiar with my Patreon, it is free for anyone to join, doesn't cost you anything, and as a member, that gives you access to every document that I upload. So I don't actually put any cost on any documents that I put up. Basically, just join my Patreon and you can get any documents that are in there for free, and you can join my Patreon for free also. There are tiers if you wanted to support my channel. I think there's a $1 tier and a $2 tier, but I'm certainly not asking for you to actually join either of those tiers. The whole point of my Patreon is to make these documents readily available to anyone who wishes to have copies. So with that said, let's just jump straight into this. Of course, what makes this even more amusing, sorry, I'm just going to butt in again, is the fact that when you go through these latest lot of emails, Stearns is there telling his parents that clearly he's got the cream of the crop in terms of his lawyers. Well, I beg to differ. And I do believe I did say that while I was reading through the emails, because it turns out his attorneys really don't understand Florida statute at all. Okay, so you've got the whole comes now, usual stuff. The defendant argues Florida Rule of Criminal Procedure 3.202 violates his constitutional rights under the 5th, 6th, 8th and 14th Amendments, because everything that has been filed by his team apparently violates his constitutional rights. How does it do it? In this case, it does it by compelling a mental examination by a state expert for the sole purpose of rebuttal against defendant's mental mitigation. Like I said, he wants to use mental health as a mitigating circumstance in the pre-sentencing part of his trial, but he doesn't want the state to argue against it. He doesn't think that that should be allowed. Honestly, if it wasn't for the seriousness of what he's done, this would be a complete, utter joke. Now, I think this argument is lacking in logic. The defendant, sound like a Kiwi there, defendant. The defendant specifically complained, sorry to any Kiwis, Rule 3.202 creates a one-sided rule of discovery that violates his protection against self-incrimination. But if you're preventing the state from getting their own expert, then doesn't that make it one-sided? I don't get that. His due process rights, as well as his right to effective assistance of counsel. Finally, the defendant asks this court to rule 3.202 is unconstitutionally vague. The defendant's inability to distinguish clear precedent rejecting their arguments leaves this court little choice but to deny the defendant's motion. I just have to read that again, because honestly this just makes my day. It just amuses me more than it probably should. The defendant's inability to distinguish clear precedent rejecting their arguments leaves this court little choice but to deny the defendant's motion. In other words, since the defendant's lawyers are really not so bright and they clearly don't understand precedent, then it makes it pretty easy to deny their motion. To be quite frank, when you look at the two lead attorneys in this case on the state side, Will J and Monique Worrell, really, Stefan would do well to just plead guilty ahead of time, and maybe then he can actually plead his sentence down, because his attorneys are so outclassed, honestly. Let's keep going. The Florida Supreme Court addressed most of the defendant's claims in its decision in Curse v. State, 2000. So we're talking something that's been in place for 25 years. In Kirsch, the defendant made nearly identical arguments that the compelled mental health examination constitutes unconstitutional, yeah, that sounds great, one-sided discovery. And this is probably where they got it from, without actually checking to see what the outcome was of this argument. And that the introduction of the expert's testimony based upon a defendant's compelled statements violates the defendant's Fifth Amendment privilege against self-incrimination and limits the defendant's ability to present mitigating evidence during the penalty phase. Curse 770. Addressing the discovery argument, the Curse Court relied on precedent in concluding a compelled mental examination of the defendant by the state was necessary to level the playing field. The court stated, by allowing the state's expert to examine the defendant, the state would have an opportunity to offer meaningful expert testimony to rebut the defence's evidence of mental mitigation. It would be unfair to permit a defendant to present mitigating mental health evidence at the penalty phase while denying the state the opportunity to present evidence on the same issue. Holding that when the court must make a finding as to mitigating circumstances presented by the defendant, the state should have an opportunity to offer testimony to rebut the defendant's mental mitigation. And really, so it should. I mean, we live in an age of paid witnesses. So, can you imagine Stearns' attorneys pay some backyard specialist to come on and say, oh, he's got mental health issues because he got run over by a car, and the court is meant to just accept that without anything from the side of the state? No way, not on your life. Far out. Concluding that allowing the state's expert to examine a defendant will keep the state from being unduly prejudiced because a defendant will not be able to rely on expert testimony that the state has no effective means of rebutting what I just said. Like the defendant, Mr. Curse attempted to rely on Waters versus Oregon to argue Rule 3.202 was unconstitutional. And here we go again. The Florida Supreme Court examined Waters and found it was not applicable. Honestly, do you think that maybe Stearns' attorneys just asked Google and went with an AI answer? Like, hello Google, what can we use to stop the state from arguing against our mental health argument? And Google AI gives this thing, and they go, yeah, that'll do, without even looking it up. Okay, sorry, too much snark. Waters involved an Oregon statute that precluded the defendant from introducing alibi evidence where the defence did not provide notice of an alibi defence prior to trial. The United States Supreme Court held that the Oregon statute violated due process because the statute did not specifically grant criminal defendants reciprocal discovery rights. The Supreme Court explained that in the absence of a strong showing of state interest to the contrary, discovery must be a two-way street. The Supreme Court concluded that in the absence of fair notice that Waters would have an opportunity to discover the state's rebuttal witnesses. He could not be compelled to reveal his alibi defence. Curse argues that Rule 3.202 is similarly flawed in that it requires the defendant to give written notice of intent to present expert testimony of mental mitigation, to give a statement of particulars listing the mitigating circumstances the defendant expects to establish through the expert testimony, and to list the names and addresses of the experts who will establish the mitigation, while imposing no corresponding duties on the state. Well, that still doesn't make sense. While Rule 3.202 does not, by its terms, require reciprocal discovery by the state, Rule 3.220 spells out very specific discovery obligations by both sides when the defendant elects to participate in discovery. By rule, Florida provides for two-way discovery and imposes obligations on both parties, including a list of expert witnesses. This is unlike the situation in Waters where Oregon granted no discovery rights to criminal defendants. Thus, we conclude that Rule 3.202 does not violate a defendant's due process rights. So basically, what he's saying here is that in Florida, discovery has to be reciprocal. So that means that they have to say who this witness is that is going to say that Stearns is screwed in the head, and they have to be provided with the report from this witness, which then means that they are allowed to have their own rebuttal. Moving on. Thus, the Florida Supreme Court has heard and expressly rejected arguments identical to those raised by the defendant regarding the fairness of discovery and the defendant's due process rights regarding compliance with Rule 3.202. So, look, we know that Will J is a brilliant attorney, but in terms of documentation, I find Monique Worrell's responses easier to read. Will J comes across as the nerdy genius who is perhaps, he probably aced all his assignments at university and he knows statute quite clearly, but because he understands it, he uses a lot more legalese and a lot more explanation than Monique Worrell. Although I think too that this could also be a little bit of him taking the mickey out of Stearns' attorneys, because if you remember, pretty much every one of the motions that they filed, they used about 1 million different precedents that they claimed proved their point, which it turns out most of them were actually incorrect and did not apply. So it is possible that Will J is basically throwing in all these extra precedents and cases and stuff to take the mickey out of these attorneys. I'm not sure. I didn't actually watch a great deal of the Sarah Boone case, so I haven't quite got his mark yet. In Abdul versus State, the defendant argued on appeal the trial court erred in interpreting Rule 3.202 by ordering defendant to turn over raw data from his mental health expert prior to the penalty phase. The Florida Supreme Court stated, Abdul's argument is that Rule 3.202 somehow preempts Rule 3.220 and that the discovery rules no longer apply in the penalty phase. But nothing in Rule 3.202 prohibits a trial court from ordering reciprocal discovery under Rule 3.220. So they're trying to say that the trial court shouldn't have to order reciprocal discovery, and claiming that that comes from Rule 3.202. But in actual fact, there's nothing in 3.202 that says that a trial court can be prohibited from ordering reciprocal discovery. Furthermore, this court has applied both Rule 3.202 and Rule 3.220 in penalty phase proceedings. Thus, the decisions in Kirsten Abdul demonstrate the defendant's argument that Rule 3.202 is unconstitutional has no merit. Right, sorry. I was thinking, where's he going with this? Each time I'm reading these things from Will J, I think he's actually arguing with the defence, and then he gets to the point of it. So basically, there's no merit in them arguing that 3.202 is unconstitutional, and it is not backed up by anything in law, anything in precedent. A review of the precedent also proves this truth regarding the defendant's argument on his rights pursuant to the Fifth Amendment. Both the United States and Florida Supreme Courts have rejected the defendant's claim that it is a violation of the defendant's Fifth Amendment right against self-incrimination to require a defendant to be examined by a state mental health expert for purposes of penalty phase proceedings. If a defendant requests such an evaluation or presents psychiatric evidence, then, at the very least, the prosecution may rebut this presentation with evidence from the reports of the examination that the defendant requested. The defendant would have no Fifth Amendment privilege against the introduction of this psychiatric testimony by the prosecution. Under these circumstances, we cannot say that the trial court abused its discretion in striving to level the playing field by ordering Dilbeck to submit a pre-penalty phase interview with the state's expert, holding that requiring a defendant to submit to an examination by the state's mental health expert before the penalty phase of a capital case does not violate the defendant's Fifth Amendment right against compelled self-incrimination. The Florida Supreme Court in Davis reasoned it would be unfair to permit a defendant to present mitigating mental health evidence at the penalty phase while denying the state the opportunity to present evidence on the same issue. Meaning precisely that. If he wants to jump up and down and say, well, I want to use mental health as a mitigating circumstance, then, of course, the state needs to be able to rebut that. And the only way they can really rebut that is by having their own mental health assessment done. Because otherwise they're basing their rebuttal on an assessment done by someone who is favourable towards the defendant. How does that work? That's not justice. If Stearns' team can't see that, they're morons. In Dilbeck, the defendant argued requiring him to submit to the state's expert would constitute a violation of the Fifth Amendment's prescription against compelled self-incrimination. The state responded it was seeking only to make the match equal, that without the exam the state was hogtied in trying to rebut Dilbeck's experts who had interviewed him. Precisely. The Florida Supreme Court held we cannot say that the trial court abused its discretion in striving to level the playing field by ordering Dilbeck to submit to a penalty phase interview with the state's expert. No truly objective tribunal can compel one side in a legal bout to abide by the Marquis of Queensberry's rules, while the other fights ungloved. Okay, that's, clearly something like a boxing match thing, but hey, whatevers. So, how can they rebut someone's testimony without expert knowledge to help them with that? So, I see exactly what they're saying here. Defendant's final argument is that Section E of Rule 3.202 is unconstitutionally vague in that it gives no guidance as to which sanction to choose. and a sanction for excluding mental mitigation violates Lockett versus Ohio and its progeny and the Florida Constitution. Oh dear, oh dear. Rule 3.202E states, if the defendant refuses to be examined by or fully cooperate with the state's mental health expert, the court may, in its discretion, order the defence to allow the state's expert to review all mental health reports, tests and evaluations by the defendant's mental health expert, or prohibit defence mental health experts from testifying concerning mental health tests, evaluations or examinations of the defendant. So that is really not all that vague. Basically, it's saying if the state gets their own expert and Stearns says, nah, I'm not going to cooperate, I'm not going to be examined, then there are two options there. One, all the mental health reports, tests, evaluations made by the defendant's mental health expert need to be handed over so they can be assessed by the expert put forward by the state, or the whole argument has to be thrown out because it's one-sided. Now, if I can understand that, why can't Lizzie Borden understand it? I mean, it's pretty straightforward. If they want to use the argument, the mental health argument, for mitigation, they already have their own specialist, and if they're not willing to, or if the defendant's not willing to allow the state's specialist to do a examination, then the only other way that the state can actually rebut these arguments is by being given all the documentation from the defence's specialist for their own specialist to examine and do a report from. And if they can't do that, then it's not a level playing field, and so the whole defence has to be thrown out. The whole mental health defence. I mean, come on, it's quite simple, it's quite basic, really. The Florida Supreme Court has held, when reasonably possible and consistent with constitutional rights, this court should resolve all doubts of a statute in favour of its validity. However, when there is doubt about a statute in vagueness challenge, the doubt should be resolved in favour of the citizen. In order for a criminal statute to withstand a void for vagueness challenge, the language of the statute must provide adequate notice of the conduct it prohibits when measured by common understanding and practice. The focus is whether the language of the statute is sufficiently clear to provide a definite warning of what conduct will be deemed a violation. That is, whether ordinary people will understand what the statute requires or forbids, measured by common understanding and practice. Okay, well, we've just answered that, haven't we? The defendant's argument is without merit based upon the clear, precise language of Section E. If a defendant fails to cooperate with the state mental health expert, the trial court may remedy the situation as prescribed under the rule. The defendant takes issue with the fact that the rule allows the trial court to decide which of the two sanctions to impose, arguing too much deference is given to the trial court and the effect between the two possible sanctions is so great it will lead to arbitrariness. A statute is susceptible to arbitrary application when it has a catch-all nature. Rule 3.202E does not contain a catch-all provision or generalising language and specifically provides the trial court with two possible remedies it may apply as appropriate based on facts and circumstances. A trial court has wide discretion in areas concerning the admissibility of evidence, and such rulings will not be disturbed absent an abuse of discretion. The defendant cites Lockett v. Ohio for the proposition that it is impermissible to impose a sanction excluding mental mitigation. The defendant's argument exceeds the scope of Lockett. The analysis in Lockett focused on a new wave of capital sentencing after mandatory D sentences were deemed unconstitutional. The court in Lockett explored the realm of what a trial court should consider before imposing a sentence in a capital case. The court focused on death being qualitatively different from other sentences and stated such a penalty calls for a greater degree of reliability. Lockett's holding was that the trial court should not be prevented from giving independent mitigating weight to aspects of the defendant's character and record and to circumstances of the offence proffered in mitigation. The Lockett court sought to assure the trial court considers all aggravating factors and mitigating circumstances of the case before rendering a sentence. Lockett is not a shield for the defendant from the imposition of sanctions for failure to abide by the rules. So basically, it's got no bearing whatsoever on this argument because it's not saying that he can ignore the rules in order to provide mitigating arguments for mitigating factors, which is basically what he would be doing were he to expect to be able to present an expert's testimony without the state first doing their own assessments. Finally, the defendant asserts there is a due process clause violation. The court specifically addressed this issue in Curse when they found we conclude that Rule 3.202 does not violate a defendant's due process rights. Therefore, this court should also find there is no such violation. You know, I just had a vision of all the state's lawyers sitting around having Friday drinks and reading the motions that have been put forward by the defence and just having a good old laugh at how incredibly stupid they are. Sorry. Additionally, the defendant claims there is some sort of right to amend his claims during the hearing or a tennis. This is legally inaccurate. The defendant, as the movant, should have his arguments confined to four corners of his motion. Ironically, this is the sort of one-sided litigation by ambush Florida Rule of Criminal Procedure 3.202 seeks to avoid. So it sounds like Stearns' team want to be able to make it up as they go along. If things aren't going well in the in the pre-sentence part of the trial and their argument for the mental health thing isn't going well, they want to amend their claims without notice and without giving the prosecution a chance to actually prepare any sort of rebuttal, which is litigation by ambush, and which, according to Will J, is the purpose of this 3.202 that apparently Lizzie Borden is really in love with. Oh, we made it to the end. Wherefore the state requests this court to deny the defendant's motion to declare Florida Rule of Criminal Procedure 3.202 unconstitutional. So, in a nutshell, basically what's happening here is that in the sentencing phase of Stearns' second trial, the one for when he took Maddie's life, let's say, he wants to be able to introduce a mental health argument. Presumably this is his brain damage one. He wants to introduce that as being a mitigating circumstance. He wants to use a specialist witness, an expert witness, who's going to do an assessment of Stearns, is going to be paid by the state, not paid by the state, paid by the defence, to basically produce a report that's going to go in favour of Stearns. However, Stearns doesn't want the state to be able to adequately argue against it. He wants them to just accept the word of his expert, and he wants them to be only able to argue based on what his expert says, because he thinks that if they get their own expert... Sorry, that noise was Mouse telling me that he wants to come up and help me with the final part of this video, which is great for him, but it makes it extremely hard talking into a microphone when you have a chihuahua in your face. So, where was I? Honestly, never work with children and animals. Okay, so Stearns thinks that if the state get their own expert, who would then have to do their own interview with Stearns, their own assessment of Stearns, that their assessment might paint him in a somewhat unfavourable light. In other words, he thinks they're going to turn around and say, this is a complete BS claim, and that he actually doesn't have any brain damage from being run over by a car when he was 8 years old, and that basically he can't use it as a mitigating circumstance. I think it wouldn't be quite that extreme, but I would imagine something along those lines. He doesn't want someone who isn't paid by his team to be basically doing an assessment of him that might actually show that he's just making up stories, he's full of BS. So his team have decided, let's take this statute and decide that it means something that it completely doesn't mean, and we'll cite all these cases erroneously, and maybe if we're convincing enough, then someone might believe us, and we can do this without having to have Stefan subjected to another assessment from someone who's not going to look quite so kindly towards him. In other words, they want to use this mental health defence, but they want to do so without the state having any option of arguing against it, basically. It's like, we want this to be a one-sided trial. We don't want the state to actually have any argument in this part, so that we can convince the jury that he's a little bit touched in the head and that's why he did it. We know he's touched in the head, but not in a way that is going to actually lead him to be more likely to do what he did. He is simply touched in the head because he is a narcissistic twat who has been enabled by his parents for the first 37 years of his life, never had to pay consequences, and subsequently still thinks that he's going to get off. So, I hope I haven't confused people with this read-through. Will J's documents do read as rather academic style documents. They're not quite as straightforward as Monique Worrell's. But that said, he does absolutely nail it every time. And I think he's made a very, very clear argument. And I think definitely if Stearns wants to use his mental health defence, he's going to have to accept that the state is going to want their own witness to do an assessment of him. Now, in case you were wondering, no, it is not my intention of going through every single response that has been put out there by the state. However, there are a few, like this one and the one about his parents, that I thought were worth addressing individually because they are somewhat preposterous. There are other ones which I will address in basically one hit, such as the multitude of motions filed attacking Florida laws and trying to say that the DP is unconstitutional and therefore should not be a consideration for this case. So that brings us to the end of this video. I will be doing some more of these over the next few days. I will, if you are interested, still tackle a few more of the interviews, just going back over them, some of the key interviews. And of course we're getting closer and closer to the trial. So on that note, I have a certain little 6-month-old chihuahua who would like my undivided attention right now, as you may have heard from the various clunks and bits in the background. So that brings us to the end of this video. So thank you for listening. If you are new to my channel, please subscribe. Also, please hit the like button, and also please leave a comment below. Thank you, and I will catch you in the next one.
I begin to wonder